Hi, this is Dave Bliven, Bronx and Westchester divorce attorney, with another episode of Lessons from the Divorce Wars. So this lesson comes in where a client of mine did a divorce case probably 15 years before he came back to me. Divorce settlement agreement said house is going to be sold pretty much right away. I think the standard language that goes into these divorce settlements is house to be sold forthwith, proceeds divided, etc., etc. Well, instead of doing that, these parties just kind of deviated, themselves off the agreement. They didn't go back to the attorneys. They just didn't sell the house. In fact, when the ex-client, now client, came back to me and said, we didn't sell the house. I said, well, why not? He said, well, I didn't want to kick the mother of my children out of the house and essentially force her and the kids out of the house. I said, that's a good reason, but what should have been done is, A, ideally you go back to the lawyers and draft another agreement. B, at the very, very least, you keep a careful paper trail. So things have to be decided, especially when there's long periods of time between the divorce agreement and when you go to actually dispose of the house. Things like payment to the mortgage, payment of, improvements on the house, repairs on the house, all that needs to be decided. And if there's not a careful paper trail, and let's say one party pays all of those expenses, don't expect a credit when you go to sell the house 10 or 15 years later if it's not in your original divorce agreement. And at the very least, if you don't keep a careful paper trail, let's say you don't do the modified agreement, which is the ideal course. If you don't email your ex-spouse and get them to agree, oh yeah, I agree to share in the mortgage or give you a credit. Oh yeah, I agree to pay the improvements or the repairs or whatever. Then don't expect it in the end. Don't expect a judge to grant that to you. The other thing too that this guy faced is he finally wanted to sell the house 15 years later. And then the wife swoops in and says, oh, yeah, but wait a second. You owe some child support arrears. You didn't pay everything that you were supposed to in terms of the add-on expenses. And, oh, by the way, you waited so long. I'm going to argue that maybe the court shouldn't order that the house get sold right now. Maybe the court should defer it for another several years. And he didn't have anything in terms of email correspondence or anything else to back him up on his claims. And so he was facing really expensive litigation. We otherwise swooped in with, a contempt motion where we were seeking counsel fees. And then because she countered with all this other stuff, he ended up having to waive his counsel fee claim. He ended up having to shave some money off the equity that he was otherwise due. So these are just lessons that sometimes people's instinct are, okay, I had lawyers involved in the original divorce case. I don't want to go back to the lawyers for anything. I just want to do things myself and keep things friendly with my ex-spouse. That's an instinct, but it can really backfire on you. And so at the very least, if you want to go your own road, that might be fine, but circle back to your divorce attorney and say, hey, is this the way to go? Do you have any concerns on my behalf if I'm going to go down this road? So that's just a lesson to take into consideration before you start doing things either in your divorce case or post-divorce case without the aid and advice of an attorney. If you're looking for more answers to questions like this, definitely check out my blog. You can find it at blivenlaw.net/blog. See you next time.